Good afternoon, everyone. Ani, bonjour, and happy Aboriginal Day. On behalf of the Law Society of Upper Canada, thank you to all of you who have joined us here for today's program and those of you who are joining us on the webcast. My name is Susan Hare, Nangosak Gasha Nadejnakas. I am an Anishinaabe lawyer from Chiging, Ontario, and I am an elected bencher of the Law Society of Upper Canada. First of all, I acknowledge the Mississaugas of the New Credit First Nation, on whose lands we are. I also acknowledge the Haudenosaunee of the Six Nations of the Grand River. Today is the Law Society's 14th National Aboriginal History Month Public Education Equality event. This event is one in a series of free public forums that the Law Society hosts throughout the year to encourage the exchange of information, ideas, and action on legal issues relating to the rights and legal needs of Aboriginal peoples and equality-seeking groups. The program reflects the Law Society's ongoing commitment to enhancing the inclusion of members of the equality-seeking communities in the legal profession. We are really pleased to host today's event in partnership with Aboriginal Legal Services Toronto and Native Child and Family Services of Toronto. We have a very full program this afternoon. To maximize our time, I'm going to keep my remarks very brief. You have been provided as well with biographical information on the panelists themselves, so we'll get right to work. I do want to note that for the first time, today's program is being offered as both a live in-person program and also through live webcast. Welcome to the participants who are joining us through webcast. At the end of the panel discussion, there will be an opportunity for questions from the floor and from the people on webcast. There is a standing microphone in the audience for that purpose, 2 of them actually. In consideration of other audience members, we ask that you limit your questions to single queries. As well, we request that you respect the diversity of opinions presented today and formulate your questions to encourage constructive discussion. Before you leave the Lamont Centre today, I ask that you take a moment to fill out the evaluation sheet included in your materials. These are very important. We appreciate your feedback always and are working to improve our education events. I'm now going to directly turn to ask Sarah Clark of Stikeman Elliott to start off our panel discussion.
I'm going to sit here, or do you want me to stand at the panel? What's better for you?
What is?
For the webcast, do I need to stand, or can I sit?
No.
I'm going to sit. If that's okay with everyone. My name is Sarah Clark, and I am now with Hensel Barristers. I was up until last week at Stikeman Elliott as a litigation associate, and now I am with Catherine, which I'm very excited about. But for the past 4 or 5 years, Stikeman Elliott has been representing the First Nations Child and Family Caring Society in various judicial review applications in conjunction with its Canadian human rights complaint that it launched. So in 2007, the Caring Society and the Assembly of First Nations filed a joint human rights complaint with the Human Rights Commission, basically alleging that the federal government underfunds on reserve First Nations children when it comes to their ability to access on reserve child welfare and child protection services. The complaint also alleges that the federal government is underfunding other types of services, mainly intense and complicated medical services for on-reserve kids who cannot access healthcare services through the province. And so what I'm going to do today, my job really is to just provide a little bit of background on the complaint, a bit of an update, and also take your questions if you have them. So I brought along this chart, which I'm not going to go through because it is a bit ridiculous, but it just demonstrates how delayed the complaint has been, how intense and litigious the complaint and the case has been, and I will highlight some of the main points because I love it as a tool because you look at it and you go, really, this is what's happened so far? And Judith Ray, who's in the audience, actually prepared this, and I think it's awesome. So just a little bit of background on how on-reserve funding happens for child protection services. The complaint was filed after numerous reports came out that were published in conjunction with the federal government that basically said that kids are underfunded 22% less than off-reserve kids. And so after some negotiation and some time at the table, the Caring Society really felt that they had no choice but to commence a human rights complaint. And so they did that in February of 2007. And it's important to highlight 2 points, and Cindy Blackstock, who is the executive director of the Caring Society, always makes these 2 points whenever she gives a talk, and so I feel absolutely obliged to share them with you. The first is that there are currently more First Nations kids in care than at the height of the residential school period. And of the 30,000 children under 14 in foster care as of 2011, nearly half of those children are Aboriginal, even though they only make up about 4% of Canada's population. And so part of the complaint alleges that this dramatic overrepresentation of First Nations kids in care is a direct result of the systemic underfunding by the federal government of on-reserve agencies. So child welfare is a provincial matter, and off-reserve, how it works is off-reserve agencies get their designations from the provincial legislation. And in each province, there's a piece of child welfare legislation that dictates how the government and off-reserve agencies are to work with families when children are in need of protection. When it comes to off-reserve agencies, the province funds these agencies directly generally, and the agency provides services to families and children in need of protection. When it comes to when it comes to on-reserve agencies, there's generally a tri-party agreement. The on-reserve agency signs an agreement saying that they will implement the legislation on reserve, but the funding comes from the federal government. And this is really where the breakdown, it's alleged, happens. What's happened over the past 10, 15, 20 years is that the legislation has developed. There are least disruptive measures required now. When a social worker goes to take a child out of the home, in general, they have to demonstrate to the court that the agency or the worker has tried as many things as possible to work with the family in order to allow the child to stay in the family context. And those services cost money. What's alleged by the Caring Society and the Assembly of First Nations is that the federal government will not pay for those services. And so the only way that an on-reserve agency worker can provide any services or any support to those children is to take them out of the home. And that's why we're seeing such a dramatic overrepresentation of on-reserve kids in care. And the complaint essentially alleges that that's inequitable, discriminatory, and is obviously affecting the long-term outcomes for these kids. And I'll just touch briefly on Jordan's principle, because the complaint also alleges that the federal government has failed to implement Jordan's principle. And Jordan's principle was developed after a young child named Jordan River Anderson. He was a 5-year-old First Nations boy from Norway House Cree Nation in Manitoba. And Jordan was born with extremely complicated medical needs. And he needed a lot of medical equipment in order to leave the hospital. But eventually, Jordan got better, he was stabilized, and the doctor said, okay, Jordan, you can go home and be with your siblings and your extended family. But in order for that to happen, Jordan needed a lot of medical equipment, feeding pump, some oxygen equipment, things like that cost money, and he needed ongoing medical care so that he could be in the family home. And what happened was the federal government refused to pay, the province of Manitoba refused to pay, and so Jordan remained in hospital for 5 years, where he died. So Jordan died in hospital, never having gone home and basically never having left the hospital grounds. And so the Caring Society worked with Jordan's family after he passed away to develop what's now known as Jordan's Principle. And Jordan's Principle essentially is this: the government of first contact pays for the services for the child that every other Canadian child would essentially get no matter what. And you can fight about it afterwards. You can go to court and litigate who should be paying for what service, which jurisdiction you're in, how the Indian Act functions into it. All of that can be done afterwards. But Jordan's principle says the child should have access to every service that every other Canadian child has, and if you want to fight about it as a jurisdictional matter, you do that afterwards. And so the complaint essentially argues that the federal government has not been properly implementing Jordan's principle, and these types of cases have been continuing to go on. Now, on the good news front, by way of update, on April 4th of this year, the federal court, in a decision called the Pictou Landing Band Council and Beadle versus the Attorney General, the federal court there said that Jordan's principle is law and that the federal government must abide by it. And that is the first decision that we've had in Canada that says that Jordan's principle is the responsibility of the federal government. But to no one's surprise, the AG is appealing that decision. They submitted their notice of appeal on May 7th, and the parties are now preparing for the appeal. No date, as I understand, has been set for the appeal. So that's what's happening with Jordan's principle. So I guess to just sort of explain this chart a little bit about how long this has been taking and the extreme frustration of the Caring Society, the Assembly of First Nations, and all of the other parties involved in this complaint. The complaint was launched in February of 2007, so that was 6 years ago. And the hearing on the merits of the complaint started in February of 2013. So it has been 6 years to get this case started to be to get it heard on the merits. And what's happened, as you can see in the chart, every opportunity that the federal government has had to raise any type of motion, they have taken that opportunity. And so they have raised the same argument at the federal court on 2 occasions, and their argument is this. Number one, they say that they are not, quote unquote, a service provider as it's defined under the Canadian Human Rights Act. Their argument is that they do not provide services to on-reserve kids, they fund it. And within the strict statutory interpretation of the Act, they're not a service provider, and therefore the Canadian Human Rights Commission and the Canadian Human Rights Tribunal has no jurisdiction over it, and the complaint should not be heard at the Canadian Human Rights Tribunal. That's their first argument. Their second argument is that for the purposes of the discrimination analysis under the Canadian Human Rights Act, you require a comparator group. And for the purposes of the complaint, the comparator group put forward by the Assembly of First Nations and the Caring Society is off-reserve kids who are receiving services from the province. So the federal government argues that you cannot compare off-reserve kids and on-reserve kids because they are receiving services from 2 different service providers. And so that argument was first brought forward to the federal court to try to get, what happened was the Human Rights Commission, without doing a full-blown investigation, decided to elevate the complaint to the tribunal. They said, we think that there's enough here looking at the documents and the submissions of all the parties to at least hear the complaint on the merits. And so that was the first judicial review application brought by the Attorney General, and we were successful in defeating that. Although technically it was stayed, and so it is out there in the ether of things hanging out there, but essentially the court ordered that the tribunal should hear the complaint. There was a change in the chair of the tribunal, and when that happened, the Attorney General brought a motion to the tribunal basically on those same 2 grounds. 1, that they're not a service provider under the Act, and 2, that you can't compare off-reserve kids to on-reserve kids. And that motion was successful. And so what the Human Rights Tribunal said was, we're not prepared to make a finding on the service issue. We're not sure. We probably need to hear more evidence on that, so we're not going to rule on that. But the tribunal found that for the purposes of the discrimination analysis under the Act, you cannot compare these 2 sets of groups. And then the Caring Society, along with the Assembly of First Nations, the Chiefs of Ontario, Amnesty International, and the Caring Society, we brought our own application for judicial review. And we were successful at the federal court. Justice McTavish said, yes, you can, for the purposes of the discrimination analysis, compare these two groups. We will see how it's borne out on the evidence, but from a strict legal interpretation, it's possible to compare these two communities. That was then appealed to the Federal Court of Appeal, and I'm happy to say we were also successful at the Federal Court of Appeal, and thankfully they did not seek leave to the Supreme Court of Canada. So that brings us to February of 2013. The hearing on the merits has now commenced. However, that's not where the story ends. A couple months ago, Dr. Blackstock, the executive director of the Caring Society, filed an access to information request with respect to some of the funding formula documents related to this case. She received some documents that had not been disclosed in the course of the litigation, and when that was raised with the Attorney General, they said, oh yes, we apologize, but we also have just located 50,000 additional documents that have not been disclosed, and we'd like to seek an adjournment until the end of this year. So a motion for adjournment was heard 3 weeks ago at the tribunal, and a decision has not yet been released by the panel at the tribunal, and we will hopefully be getting that decision soon. The panel is reconvening on July 15th, so that's when I guess we will find out what is happening. So that was kind of a whirlwind, blistering, quick, fast-paced overview of the past 6 years of litigation when it comes to the complaint. But I guess I did want to touch on a few things, basically that Catherine told me I should talk about, when it comes to working with a client, an Aboriginal group as a client. In this case, the Caring Society is generally a representative organization. They're a not-for-profit policy organization that works with and assists on-reserve child welfare agencies. They are engaged in a lot of advocacy work, research, and policy development, and so that's the context in which I've been working with the Caring Society. And I think probably the most important thing that I can share in my experience is that as a non-Aboriginal woman, I have felt very strongly that I needed to ensure that when I was speaking on behalf of the Caring Society, that what I was saying and how I was saying it was done in a way that Cindy was comfortable as the executive director. And so I communicated and continue to communicate a lot with her about how to approach issues, how to deal with certain issues when they come up, and you know, we really to check my assumptions as I've been moving through this case with her. Just by way of background, when I was doing my MSW at Carleton, I was an intern at the Caring Society when it was Cindy Blackstock and an assistant, and it was a teeny tiny little office in a cubbyhole in Ottawa. And so you can imagine how intimidating it was for me not knowing anything about anything, really. And Cindy is extremely gracious and dedicated to working with anyone and everyone that basically will help on this issue. And so I felt extremely privileged to be able to represent the Caring Society in this case. And it hasn't been without difficulty, and it hasn't been without its own problems. This case is extremely complicated when it comes to the evidence. Every province has a different system. Numerous agencies have different types of agreements with the government, and all of that is going to come out at the tribunal hearing, but that's one of the reasons why it's been taking so long. And when it comes to potential outcomes, I think one of the reasons that we've been fighting so hard for this case, and others have been supporting the Caring Society and the Assembly of First Nations on this case, is that it's possible that this will pave the way for other really important issues to come behind it. If it's found that the federal government must fund services of this nature equitably compared to off-reserve communities, that opens the door for things like healthcare and education. And we feel it's been very important to do this work. And Stikeman Elliott has been extremely supportive. Stikeman Elliott has been doing this work pro bono. We've been on this file pro bono for 4 years now. And so I'm very thankful and want to acknowledge the contribution of Stikeman Elliott supporting this cause. It's been amazing. So I'm supposed to talk for half an hour, but I don't really think that I can. I could go into more detail about the case and be happy to answer any questions. But really, I hope that you follow the case. You can go onto the I Am a Witness website, which is on the First Nations Child and Family Caring Society website. All the court documents are there, all the affidavits, all the testimony. APTN has been broadcasting as well, the hearings, so you can live stream that or watch it when it starts again, all the cross-examinations and the argument by counsel. And so I encourage you to go on there and to check out the information, and I will be happy to answer any questions whenever Susan tells me to.
I think we'll leave the questions for the end of the panel discussion. So thank you, Ms. Clark, for condensing probably 3 hours of a fulsome lecture into almost a half an hour. Thank you very much. We'll proceed next with services available to support Aboriginal families. And here to talk about that are the Native Child and Family Services Council today, Edith Summer-Weisglass, and Jonathan Redden from Aboriginal Legal Services, Toronto. So we'll begin first with Ms. Summer-Weisglass.
Good afternoon, everybody. And I'm going to apologize in advance. I think I'm the only one that actually did do a PowerPoint, but I hope that...
I had one slide.
That's true. There'll be some stimulation. Now, do I have to move over there to...
Just the slide clip is over there.
Okay, hang on a second.
This thing? Was that terrible?
That was great. Good job. What you see on the first slide is our logo at our building at 30 College Street. It is a wonderful, beautiful building that in some ways reflects how we are doing our work differently and incorporating Aboriginal ceremony and culture right into our physical space. So I do invite you to come and visit us. Am I supposed to point it somewhere? Oh, there. So the first thing, and this is probably all you need to know, is the mission statement of Native Child, which is to provide a life of quality, well-being, caring, and healing for our children and families in the Toronto Native community, with a service model that's culture-based, respects the values of Native people, extended family, and the right to self-determination. And that's pretty much what we try to do on a day-to-day basis. Native Child has been around, if my math is correct, for about 28 years. It started off just providing support services to the Aboriginal community. And in 2004, it also became a licensed mandated Children's Aid Society under the provincial government. We consider ourselves a multi-service agency because we have clinical services as well as child protection services, and we continue to work very diligently to provide services to the families holistically. We also, I believe, have the honor of being the only sort of urban Aboriginal mandated child welfare agency, in the sense that we service the self-identified Aboriginal community in the city of Toronto. We don't have a particular mandate from First Nations in our jurisdiction, which is what the other mandated agencies in the province of Ontario have. And again, the clients are self-identified. They can be status, non-status, Métis, Inuit, and we have had clients from other Indigenous communities in North and South America who feel that the way we deliver our services are more congruent with their worldview. So I'm going to go quickly through the services to the community, which is where we started in 1985 and which we continue to do on a much more expanded basis right now. There were some brochures out at the front which really go into these services in detail, so I'm just going to give you some of the highlights. We have a very extensive early years program, which is providing service to families and children under the age of 6, because as we all know, early intervention, early education is a good step to positive outcomes lifelong. So we have 4 Aboriginal Head Start programs across the city. We have 2 daycare programs. We have an Aboriginal Early Years Center, which is located at our College Street location. We run pre- and postnatal nutrition programs, home support, monthly cultural events, and our Nanoches, our aunties, do the parent education and support in home to the families. We have recently reformulated our clinical services into a more treatment-focused model, and we, I think in the last month, opened up a separate location for that at 489 College Street. They're basically set up into 3 teams. The healing preparation team, which includes services like social workers in the school board, developmental service workers, children's mental health services, transitional support for women in family violence situations, adult women healing, individual and groups, and we have an original dispute resolution program, which is kind of a combination of a family group conferencing and talking circles. It's a way to bring all the families and their supports together to try and resolve clinical and certainly child protection issues. They also run some groups. The healing team takes over from the prep team, and actually that was the services for the healing team. The prep team is also a case management and trying to ensure that the filling in gaps in service. We have a location at Kingston Road in Galloway. It's called the Scarborough Child and Family Life Center. That's where we have one of our daycares, youth programs. It's a beautiful building, as you can see. It used to be just in that old little house, and then we built a beautiful building, lots of light, and we run a lot of the support programs from that location. So we take the services to the community because that intersection, Kingston and Galloway, there's an Aboriginal housing complex. I think it's kitty corner from the building. So the services are brought out to the community. There's lots of evening programs for after-school programs, homework programs, children's dance and cultural programs. It is a very busy, busy place all day long and into the evening. The Native Learning Center one of the Native Learning Centers runs out of that program. They have full moon ceremonies, drumming, social and recreational for children. They have a family community council. Anything you can think of that a family might need, they can access at that particular location. We've just recently, again, I think in the last month, relocated our youth services into a separate building to coordinate all of the services that we offer to Native youth. 16 to 24 years is primarily the catchment area. They have social and recreational programs, cultural, skills training, education, health outreach, youth justice, and we have a very special program, the 7th Generation Image Makers. They have a mural program. It's a way to engage the youth, to help them express their culture, and to learn. They have all kinds of skills with computer and art and so on. We also run some transitional housing program. We have the women's program, which has two separate programs. The first stage, which is a 10-bed unit for women and children, women 16 to 24 years of age. It's a sort of group living, on-site support. The woman has a room with her children. And then when they're ready, they can move from first stage into the community or into our second stage housing, which is a more independent arrangement. There's basically six apartments. with support on site if they need it. And I think it's pretty much across the street from the first stage housing. The men's transition house is a similar type of program for men 16 to 24. Unfortunately, there isn't an arrangement where a single dad can bring a child or use the program to work on a plan to have primary care of his children. But it's a thought. It's something that we're thinking about. So we have the Native Men's Transition House, and they get all support. There's group work and individual work, and they can access all of the programs through that service. So, and then we are also a Children's Aid Society. So those are just some of the statistics with respect to our child welfare branch. We have, at the moment, about 49 families before the child welfare court. Those 241 children in care, some of them are long-term Crown wards that we assumed carriage of when we became a mandated agency. Some of them are in voluntary temporary care agreements. Some of them are under our supervision, and they appear in those statistics under customary care, even though their legal status is not in care. And a number of those children in care would be by court orders, and they're in progress through the court system. You can see that the primary reason for our involvement of the Child Welfare Service is neglect of the children, and that generally arises out of parents dealing with substance abuse, mental health, and family violence. And looking further back, you can look, the root of that is often in the family dislocation arising out of many of the historical factors that I think Catherine will be touching on in more detail. Now, I know this is primarily a room of lawyers, so I wanted to just briefly bring to your attention some of the provisions of the Child and Family Services Act that help guide how we do our work. And they relate to the sections of the Act that talk about recognition that Indian and Native people should be entitled to provide their own child and family services. So that's the paramount purpose of the legislation applying to all children in the province. And this is the section that really needs to be kept in mind when you're dealing in child welfare with Aboriginal families, is that element of self-determination to provide those services that the community knows has been providing care for their children for forever, and that they, just like you look at the family knows best what's the family, the communities will know how to provide service to the families and to the children. Now, what you should know also is that in the province of Ontario right now, there are 7 mandated fully licensed Aboriginal child welfare agencies across the province, and 6 that are what we call pre-mandated agencies, that they are providing the support services as we described earlier, and that they are working towards receiving full license so that they can then assume the child welfare mandate for their member children, the children of their member First Nations. And I want to let you know where those agencies are, just so that you can see that when you come in contact with a child welfare file, that there is likely an Aboriginal agency that is connected to the First Nation that the family comes from, and that they can be of assistance in moving the case forward in a good way. So you have Akwesasne in the Cornwall area, Anishinaabe Abenuji out of Kenora, Daliko Anishinaabe Family Care out of Thunder Bay, Peokatano out of, it's the James and Hudson's Bay area, and then Native Child and Family Services in Toronto, Tikanagan Child and Family Services out of the Sioux Lookout in the northwest, and Wichitawin out of Fort Francis. So they service the First Nations in their geography, and let me tell you, they have to travel to fly-in communities, and so that their resources are stretched just by their geography. to a certain extent in terms of reaching out to the families. Now they have central offices, but they also provide service directly on reserves. So there are some mandatory sections for the courts in terms of considering the child's culture and heritage, that when you're talking about best interests and you're talking with an Aboriginal child, a First Nations child, the court shall take into consideration the importance of the child's heritage when they're making dispositions about the child. Part 3, which is the protection proceeding, has numerous sections related to consultation with the child's First Nation, notices required to the child's First Nation. You need to know that the child's First Nation is a full party to any child welfare proceeding, and that when the court is going to make a disposition, sections 57.5, if the court is not in a position not prepared to return the child to the parents, the court shall place a First Nations child with family, extended family, another First Nation family of the child, a family with the child's First Nation, or another First Nations family, unless there's substantial reason not to do so. There's substantial reason otherwise. So that's a very significant test that needs to be met in order to not keep a First Nations child with family or with their First Nation. This is the section of the Child and Family Services Act that also speaks to consultation and starts the discussion of customary care. So Section 213 tells the societies that they shall regularly consult with children's First Nations when they're basically providing any form of service to a First Nations child. They've opened up the file for ongoing service. You must be regularly consulting with the child's First Nation. Now, consultation is not defined. It has to mean something more than calling and asking, what would you like us to do, and then filing that information away. I would say that the best practice is more of a collaborative approach, where the child's First Nation is actually a partner to the planning and for the child. And then the next section is a reinforcement, requiring the agencies to consult with the First Nations. And the regulations set out the timing for that. So I think one of the things I was going to be touching on was just the customary care. So this is customary care in a child welfare perspective is really the customary care that falls under Part 10 of the Act. This is sort of an outline of what traditional customary care would be, which is basically if a parent can't care for the child, a family member would, someone on the chief and council, the elders, the grandmothers, the community would look after the child and it's not a way to sever parental rights or relationships. It's a way of making sure that the child's cared for. It's kind of the original "takes a village to raise a child," but it's not a cliche. It's the way the families have lived and the way they continue to live as best they can. And that's part of what Native Child tries to do, is to be that community for those families that live here in Toronto that don't have that aren't living in the traditional communities. So the Part 10 customary care is defined in Section 208, really just care in accordance with the custom of the First Nation. It doesn't say much more than that, but it's structured by the Ontario Permanency Funding Policy Guidelines. And very recently, that's just a quick list of what the guidelines require in order that an agency enter into an agreement that can then be funded. So those are the requirements. Now, what the ministry has recently produced is a practice guide. This is what it looks like, and you can access it online either at the Customary Care site or at the ministry's own site. And it talks a little bit about the history and why the guide is produced. It's to encourage primarily the mainstream agencies to work with the First Nations and the First Nations agencies to use customary care as a disposition of choice for First Nations children. They don't have the status, legal status of in care. There's no timelines. There's no timelines to terminating parental rights. It's, I like to describe it as, we've tried to struggle to describe what the status of this child is, because everyone is used to, well, is it a society ward or Crown ward or whatever? So this child is the shared responsibility of the signatories to the Customary Care Agreement, which would be their First Nation, their parents, the caregiver, and the Children's Aid Society that is funding it. So it's the shared responsibility of all of those parties. The roles and responsibilities are set out in the agreement, and it's for as long as necessary. It's a voluntary agreement, and it's to provide for all of the child's needs, including a connection to their First Nation, their culture, and their family. Let me see. How do we do child welfare differently? I had to sort of think about it because it's something we work hard at on a daily basis. It starts at our front door in terms of how our building is set up. We have, there's a beautiful lodge built right in our main floor for ceremony, for meetings that take on a very different tone when you sit in the lodge. Our main floor is a public space. You will find families interacting. Our early year centers access through there. Our Monday night cultural night, there's dinner and dance and music and activities for the children. We have a very large community kitchen right on the main floor that is used for all of our programming. We have a wonderful green roof that has a sweat lodge that can be used for ceremony as well. We try to provide the service using the Aboriginal worldview, which is more of a collectivist worldview with the responsibility of the community to help the individual to address their needs. We try to incorporate culture and ceremony in all of our areas of practice, certainly in the clinical realm and even in the child welfare realm. When we do meetings, when we ask families to come together and to bring their supports. We have a band engagement worker. Alan Kennedy, his specific duties are to reach out to the First Nations, to tell them who we are and how we do, and to invite them to tell us what they need from us to provide service to their members who reside in the City of Toronto, and to work with us and to what we can do to make it easier for them to participate in the plans, children's plans of care, and so on. So we specifically have. All of our workers are able to reach out and to speak to the First Nation band reps when the First Nations are able to have that position. But we have a specific worker, Alan Kennedy, who reaches out on a larger scale to ensure the First Nations, because we're far from them and they don't know us, how we do our service, and to ask them what we can do better for them. We also provide our service, including the child welfare services, recognizing the intergenerational trauma and the on-the-ground challenges for our families in the city, the poverty, the housing issues, mental health challenges, and so on, that all of those things impact our parents and families in their ability to respond and to you can't just give families a list of things to do. These things impact how they respond to those. So there's a different approach to trying to provide the service in recognition of where the families have started from. And I think that's my time. Right?
Okay.
Thank you very much, Edith. I would make a comment at this point that Native Child and Family Services talk the talk and they walk the walk as well. We had a very successful customary care agreement with children from Manitoulin Island, which involved Ms. Hensel and myself and Ms. Summer Wasteblast. So I'm very pleased to hear about more of their services today. On the continuation of services, I now ask Jonathan Rutten, the Program Director of Aboriginal Legal Services Toronto, to take over.
Thanks, Susan. I'm very pleased to be asked to be on this panel. Many of the panelists I know, and now I know you. And it's nice to see people here that I know, and it's also particularly nice to see people here that I don't know, because it means that there's interest in this beyond the narrow circle of people I know. Aboriginal, I don't have a PowerPoint. No, you should know. It's nothing to apologize. I'm not apologizing. I'm just saying I don't have a PowerPoint. If you're watching and you don't have a PowerPoint, thank you.
Order.
Thank you. Thank you. We know each other too well. Aboriginal Legal Services began in 1990, and our mandate and our mission statement includes returning control of justice-related services to Aboriginal people. That's what we do. It's part of what we do. And one of the first projects that we undertook in beginning in 1991 was a program called the Community Council, which was an Aboriginal justice program, and it took Aboriginal criminal offenders out of the criminal justice system and had them dealt with by members of the Aboriginal community. And we found the program worked very, very well and was making real impact in people's lives in a way that the criminal justice system was not able to do. And so after a couple years, we thought, maybe we should think about the child welfare system too, because there are huge problems in the child welfare system, and Adit's touched on some of them. I mean, once, some of you know, when the Indian Act was amended in the late 50s, child welfare agencies, provincial child welfare agencies were given jurisdiction to go on to reserves, and they did with a vengeance. And what occurred is now generally known as the 60s scoop. There are communities where all the children were taken, where it was impossible to place a child who had been apprehended back with anyone on the reserve, because none of the houses on the reserve met the provincial standard for what a house had to be if you were going to take a child. So that's 50 years. There are 3 generations, in some cases, of Aboriginal families who have histories with child welfare, and generally not particularly pleasant histories with child welfare. And there are some people who still, but when a child is apprehended, there are some families, and Native Child, I will say this a couple times, Native Child has a great array of programs. But in order to access them, you have to be willing to make that step. And for some families, the fact that a child has been apprehended is the end of the process. They can't see that this is going to end any other way, but that the way it's ended for their parents and their aunts and their children, which is their children are going to be taken into care. And so they give up. They don't participate. So that's one response. And the other response that we see, not all the time but often, is this denial response, that I did nothing wrong, it's all you people are all whatever. And again, it's often a response that isn't particularly helpful in the long run. The other real challenge in the area of child welfare, of course, is that when a family, and particularly when a woman has a child apprehended, and if she loses that child, often what she does, as quickly as she can, is try and have another child, because that's going to make up for the problem. But of course, if she hasn't done the work that's necessary, that doesn't change the problem. It just means that more of her children are apprehended. And in some cases, it gets to the point where the people in the room, in the hospital where she's giving birth, are the child welfare agency. There are people, we have clients who've had 6, 7 children, all of whom have been apprehended. And so this is a cycle, just as the revolving door cycle that we see for Aboriginal people in the criminal justice system has to stop. This cycle also has to stop. We have to find ways of stopping it. And the court process has generally not been particularly successful at doing that, because that's not really what it's set up to do. It's set up to resolve a particular question, legal question at the moment, which is what is in the best interest of that particular child. And so very early on, as I said, we thought we would like to look at trying to find another way to deal with child welfare issues. And we thought about something that we tentatively called the Child Welfare Community Council, and we worked very closely with Native Child starting about 1993 to try and come up with an alternative process for child welfare. And we didn't work on it full time. We couldn't work on it full time. But there was a corner of my desk that was for that. And we made, there was some success, and then no, and then yes, and no. Anyway, eventually the Child and Family Services Act was amended a number of years ago. And in that amendment, it required child welfare agencies to consider alternative dispute resolution, ADR processes, in all cases. And ADR was defined as mediation, family group conferencing, other, and Aboriginal approaches. And to the ministry's credit, and I do give them huge credit, they did not attempt to define what an Aboriginal approach to child welfare dispute resolution would be, and that is fantastic. Because whenever governments start defining these things, well, they screw it up, frankly. So, and the reality is that the different communities are going to respond differently. So once that came about, the ministry had this ADR process. They also wanted to try, and they funded ADR approaches, partly because it's a good idea, partly because they think it will save money because court cases are really expensive. And so out of that, Aboriginal Legal Services set up our Child Welfare Community Council, again working with Native Child. And it's a process that's undergone some evolution over the years. A number of years ago, we received an Ojibwe name for the program from Jake Agone, and we had a ceremony at our office, and we asked Jake for a name for the program, and he asked the spirits for a name, and he said the name of the program is Giwade Nanang. I don't need to say any more because it's self-explanatory, of course, so I'll just... so anyway, Giwade Nanang means North Star, which, you know, when I had no idea. He said, it's Giwade Nanang. I went, okay, it's North Star. And I went, I'm appreciative, of course, but in my head I'm going, I have no idea why North Star. And then it was explained to us, when you're lost, traditionally, if you're out and you're lost and you want to find yourself, what do? If you want to find yourself, you look up and you find the North Star. When you find the North Star, then you can find some direction. And that's why the program's called Giwade Nanang, because the program is there for Aboriginal families and Aboriginal and child welfare agencies as well, who want to try and find their way out of a particular problem. And the problem that we work with are those families who are not able, in the case of Native Child, to use the other services that are there. For whatever reason, there is a breakdown. Sometimes that breakdown happens, as I said, right off the start, because the person just will not listen to what the child welfare staff have to say. Sometimes the breakdown happens later because people are misinterpreting each other's behaviors. But when there's a breakdown, that's often when apprehension happens, because as Adit points out, most of the families that come into Native child care, and there are still some Aboriginal families with Catholic Children's Aid and Children's Aid of Toronto, and this is true not just for Toronto, but generally, most Aboriginal families that come into conflict with and have children apprehended, it's on the neglect issue. It's not abuse issues, it's neglect. And what neglect speaks to often is the the inability of the caregiver to provide the care that they want, and sometimes simply to respond to what the child welfare agency thinks is a legitimate thing to ask them to do. And at some point, the child welfare agency says, can you do X, can you do Y? Person isn't doing it, then the ultimate step is apprehension. And so the idea behind Giwe Nanang was to provide a different way and a different venue where matters might be addressed after a child has been apprehended. What distinguishes the Giwe Nanang program from almost all, I think all ADR programs that I'm aware of in the province, most ADR programs are controlled by the Child Welfare Agency. The legislation requires the Child Welfare Agency to consider whether ADR is appropriate, which means that the Child Welfare Agency has an internal process where they say, here's family X, is it appropriate for ADR? And if they say yes, they go to the family and say, here, we have these ADR options, and they'll explain them to them. In some cases, there will be Aboriginal options. There aren't a lot of Aboriginal options available in the province. But if the Child Welfare Agency says, we don't think it's appropriate for ADR, then they have done their duty under the Act, and things move on. What's different about Giwe Nanang is that through our staff, we have a family court worker in the family courts. We tell clients that this is an option available to them. So we try and give some agency, that's the current buzzwordy term, I think. We try and give some, anyway, we give some power back to families and say, look, do you want this? And so they have the opportunity to say, I would like to have this process. And then we then contact the Child Welfare Agency, which most times is Native Child, and most times Native Child says, yeah, let's do it. But one of the significant things then is that's important for us and for the families is that they start to feel that they have a say in things. And again, when you think of the history, that's not something that people get a lot. And so it's one of the things that's very important about the program. The way the program works, and it has evolved over time, we hold circles, and the circles consist of volunteers. We work with volunteers. They're members of the Aboriginal community who, some of them are elders, some of them are traditional teachers, some of them are members of the Aboriginal community who have their own experiences. They have training in the Child and Family Services Act, but we don't tell them how to do what they're going to do. Our programs are based on the notion that the Aboriginal community has always had, since time immemorial, has known how to deal with issues in the community. That's how communities live, that's how nations live. And so if you give that back to the community, you don't give that back to the community and say, it has to look like this or it has to look like that. So the members of the council figured out how they want to work. We work in a circle. We have an elder at each session. The sessions usually begin with teaching, and then people talk. And we try not, and this is one of the changes that's happened. When we started, we thought, let's see if we can get all of this worked out in a day. Let's see if after someone's been apprehended, we can solve everything, and then people can go back to court. And that doesn't happen much. Rather than start with a huge plan, what we start with is let's start talking, and let's identify a particular issue. And let's then see what happens in a month and give, the individual, the client will say that they will do things, Native Child, or if it's Native Child, it usually is. They say, if you do this, we'll do that, or we'll do this. And then we'll come back in a month. And what we're trying to do, as most restorative programs are repair relationships. Repairing relationships, hopefully, ultimately with the parent and the child, but the immediate relationship that needs to be repaired is between the parent and the Child Welfare Agency, because it's not working. And as long as it's not working, the matter's going to continue to be before the courts. And so that's the idea behind the program. And sometimes we have 2 circles, sometimes we have we try to cap it about 4, but we have had cases where we've had 5 or 6 circles. You know, you don't, it's stupid to say, well, we can only do X or Y, because what you need to do is respond to the needs of the client. Lawyers are not welcome, generally, at any of our alternative processes. They're welcome in other things, but they're not welcome in our criminal justice program, and they're not welcome in Giwe-Nanung. There is a more diplomatic way to say it, but I don't know what it is. So, and I don't want people to miss the, I don't want to be too subtle. It's not that there aren't room, it's not that there's not room for lawyers. There is, particularly if you're in court. But if we're trying to solve problems, lawyers aren't always the greatest help. And I say that with respect to both lawyers on behalf of clients and lawyers on behalf of the Child Welfare Agency. We would rather keep lawyers just out of the room altogether. The one lawyer we can't keep out of the room is the Office of the Children's Lawyer. The OCL, if there isn't a children's lawyer appointed, they do have a role. We did have one case where the children's lawyer said they would not let their client, the child, who was a teenager, participate in the process. But we went ahead anyway. I don't know if I should have said that, but you can't. I mean, people are getting together and they're doing what they're doing, and we're not going to. I mean, the child can take the OCL's advice or not, but we're going to go ahead. We use Giwe-Nanung not just for child welfare matters. We have had families where it's there's simply been a separation, and the parents or the grandparents, or anyway, they can't agree on things. If people are prepared to come to Giwe-Nanung, we're happy to try and work things out. We work, as I said, not just with Native Child, although primarily with Native Child, because they have the bulk of the cases, but also with the other child welfare agencies in Toronto. And we're also prepared to work with child welfare agencies in the GTA if they're interested as well. Our experience, and one of the things that's interesting that's happened in the last little while is that we've now been doing cases prior to apprehension. We've been approached sometimes by Native Child, sometimes by the families, and said, look, we don't want to have Native Child say, we don't want to have to go to the next step, and we're not sure why things aren't working, but maybe you can help us figure out why things aren't working. And we have families who say, you know, I'm concerned X isn't happening, I want to know. And those things often, it may take one circle. Sometimes, frankly, and this is very much to Native Child's credit, sometimes we'll get a family who'll come in and say, I want a Giwe-Nanung circle, and we'll get a consent form and we'll send it to Native Child and say they want a circle, and Native Child will go, really? So they'll look at the file and they'll just talk to the individual, and it'll all get worked out. We don't even need to be involved. Sometimes people don't even know there was a problem. And part of that is, again, it's not easy. As receptive and as open as you want to be, it's not easy for people who are used to being shut out, who are used to never being heard, to even ask to be heard. They just don't know how to do it. And so sometimes coming to us and us talking to Native Child means that Native Child says, oh, I guess there's a problem and we didn't know. This is true as well for counsel. You know, we talk about clients as though they're hiring us and we're working for them. But the reality is the experience of most of our clients is not that. They don't actually feel that their lawyers are working for them. Not that they don't like their lawyers, but their lawyers are telling them what to do, and they think that's what they have to do. And they don't feel that they have a huge amount of say in the process. And it's that sort of almost fundamentally, I think, is really crucial in this work. All this work is trying to make sure that people feel that they actually have a choice. Because you can say you have a choice. You can say, I'm here for you, what do you want? And then you proceed to tell them what they need to do or what they should do. But you're dealing not just with the individual, but you're dealing with their experiences and their family's experiences, their parents and their grandparents' experiences, and those have generally not been great. So our hope with Giwe Denang, and we've learned a lot from other programs. Anishinaabe ASCII Legal Services has a Talking Together program that works in the north. We've learned a lot from them, and we try and share our experiences. The courts are a place where a dispute gets solved. It doesn't, or it gets resolved. It may never get solved, but it gets resolved because that's what courts have to do. But those resolutions are often difficult. The process of arriving at the resolution is difficult. It's painful. It's hurtful. People remember all sorts of things that are said by anyone. You know, they will recite when a lawyer said this, or they read X in the report from one of the workers, and those words, they may have been a whole bunch of other words, but what the words that stick with them are the words that sting and hurt, and they carry those with them. And there's no way to get at that in the court process because it's a very, for good reason, very formal process. So the idea of Giwe Denang is to try and take it out of that, to return back, to give people teachings from elders so that people are there, so that everything we do, we try and treat everyone with kindness and respect. And if we do that, our experience is that really good things can happen. And we've been very pleased with how the programs work to date, and we're excited to see where it's going to continue to go. Thank you, Miigwech.
Thank you, Mr. Rudden. I especially want to thank you for, talking about the heavy burden that's placed on the family and parents when they go through this process. We talk about it from a legal point of view, and we talk about it from Children's Aid Society point of view, but that's very, very important. Thank you so much. We will now move on our agenda to Ms. Catherine Hensel. She's the principal of Hensel Barristers, and she will talk about working with Aboriginal families and children in terms of practice management and competence considerations for providing legal services to Aboriginal children. Ms. Hensel.
Thank you. Catherine Hensel Insquest, as you heard. Hello, everyone. My name is Catherine Hensel. I'd like to, I'm Secwepemc myself, so these are not my territories, so I would like to thank the Mississaugas of New Credit, as well as the Haudenosaunee people, for allowing me to live and work in their territories and for us all to attend here today. And I say hello to the members of the judiciary I see here and many friends and colleagues that I've known for years and years. And also thank you to the Law Society for organizing this, and particularly Marisha Roman for organizing this event in celebration and to acknowledge National Aboriginal Day here. I also really, since we're sitting here and we're talking about services that are available to Aboriginal families in Toronto and throughout the province, and want to acknowledge the work that is done by Aboriginal Legal Services and Native Child and Family Services, as well as the myriad other agencies across Toronto, and just personally and professionally, they've had a transformative effect on me and my own ability to deliver professional services in a competent and ethical way, or in what as well as my understanding of what my own obligations are with respect to competence and ethics, that really allow me to do the work that I do. I work, and I now work with Sarah Clark in my office. Isn't that exciting? She joined us last week, and I'm very pleased. Anyway, about most of what we do is litigation, not all of it, but the majority of it, and most of it is on behalf of First Nations. Some of it's on behalf of First Nations individuals or other Indigenous people, and organizations, Indigenous organizations, tribal councils, commercial entities, but a good 30 or 40% of the work I do relates directly to children, particularly Aboriginal children. Most of that work is litigation on behalf of a First Nation who has standing under the Ontario's Child and Family Services Act for all the applications and child protection proceedings involving their members. Some of the work I've done has been on behalf of individual mothers primarily, and I've also had the privilege of providing independent legal advice and representation to customary care providers, grandmothers, other community members, including, as Chair Hare noted, a member of her community on Manitoulin Island. And I have to say that there is so much that one needs to know to not only be competent and diligent in this area, but to not do tremendous damage as a lawyer, as a professional, that we are not taught in law school, although I was exposed to some of it in law school at University of Toronto, actually, partly through Jonathan Rudin coming in to speak, partly through Kent Roach. And the Law Society is now trying through programs like this, and I understand that there's a national initiative amongst the law schools to improve the competence of people involved, lawyers who work in the child welfare realm. And I would like to see that addressed, given that so many of our children are caught up in that system, more than any other group, that initiative specifically and robustly address the needs of Aboriginal children and the competencies and ethical considerations around working either in relation to them, for them, but that work is really only beginning. And I regret to say that much of the work that is done in this province by members of our profession relating to or on behalf of Aboriginal children is not competent. I'd go so far as to say it's grossly incompetent, and for a number of reasons, and tremendous harm results. So I'm happy to be here and to be doing this work and continuing with this educational process for the profession. But I just note that my assessment on that. I'll give you a few, I'm not going to give you concrete examples. Well, maybe I'll give you a few, but they'll be sanitized. Adit spoke about the requirement under the Act, the Child and Family Services Act, for agencies to consult with First Nations when they're providing services to any of their members. I can tell you that certainly amongst the non-Aboriginal, this is not true of the Aboriginal agencies that I've worked on cases with, and I don't generally work, or I haven't had the privilege of working for a protection agency, but when I've represented First Nations, the Aboriginal agencies are proactive, they respect the statutory imperative, and they're competent to fulfill their obligations to it. Unfortunately, many of the other licensed agencies do not have the wherewithal and largely ignore that particular statutory requirement. And one of the reasons is both at an operational and social services level, and as well as at the legal level with their counsel, they don't know how. They may call, they don't know how to consult with and engage a First Nation in a way that's both respectful and effective. And in order to be effective, it's got to be respectful. So it's not unusual to hear workers and agencies and then their counsel on their behalf say that a community was consulted because a message was left for the chief. Now the chief gets a lot of messages, and it's not actually his mandate. There are generally, although not always, and so in some communities, in smaller communities, the chief actually does engage on these issues. But many communities have band representatives. They aren't funded. So if the band representative is who's the person who's appointed by council to articulate, to represent the First Nations collective interests with respect to children who are involved in protection proceedings, that money's been diverted from another program to pay that person if they're paid. So that's important to know. some of the issues that, that Sarah was talking about in the First Nations Caring Society case about discriminatory underfunding of First Nations applies across the board to all services, and administrative, operational, social services, preventative, not necessarily protection, but, well, that case addressed that. But so the capacity of the First Nation to respond in a way, in that brisk and prompt way that you might otherwise expect from a fully funded government entity or agency, that may not be possible. But that doesn't mean that one phone call discharges, and a message left discharges the obligation under the statute, I'd say. So, or the agency's obligation. And if you don't know who to call, and you're just leaving messages in the general mailbox for the band, and the receptionist who checks those messages may not know the significance of it, then no connection is going to be made, and nobody's obligations, either the First Nations obligations to its members and its children and to its collective with respect to the children, or the agency's obligations under the Act are going to be discharged. So, but people who know Indigenous communities know that sometimes it's going to take several calls because of the capacity issues, the scarcity of resources, and you have to know who to call. And a lot of it's online, right? Who the band representative is. If there's a prevention service, they will know. Chances are they'll know the family. Sometimes, if I need to get through to a particular First Nation about one of its members, you know, I know someone who will know someone who will know someone, which I'm not suggesting that that's an element of cultural competency, but if you understand that every First Nation is different, every First Nation has a different level of accessibility and a different level of resources to bring to bear to these issues, and you understand that persistence and some level of ingenuity and knowledge is necessary, then you'll be able to discharge your statutory obligation. And if you don't know that, and you just leave a message in the general mailbox or fax something into the band office where it may sit on a fax machine, this is incredibly confidential information about children and their welfare and allegations of abuse, maybe. Should it be sitting on a fax machine in the general administration office where members pass through all the time? No, it shouldn't. So it's important to know. These are things that you should know, unless you're going to, well, you got to discharge your obligations, and you also got to try not to do any more harm than's necessary in the process. The other, I'll give another example of cultural competency, and this goes across the board in working on behalf of and with First Nations, but it does come up in child welfare. As I said, I represent First Nations, the chiefs and as they are represented by chiefs and council often in child welfare applications and litigation. And I'll just tell a bit of a story. I was with some very senior non-Aboriginal council taking instructions. I met with a chief and council up north, and I was a junior at the time, more junior and less assertive than I might be now. Hard to imagine. Anyway, we were sitting with chief and council, and the lawyer really wanted to get some instructions. He was providing some advice, and in fairly forceful terms, this is what I think, this is my analysis of the law, and this is what I think you should do. You all think I should do that, right? And chief and council's response was to stare at the table. They didn't ask any questions. They didn't disagree with him, but they didn't respond. So we left, and I was very uncomfortable. So we walked out, and the lawyer, was very happy. He's like, "Okay, we've got our instructions." Because surely they would have said something if they didn't agree with me. And I said, I won't say his name. They're all angry at us right now. Well, they would have said something. Well, no, they wouldn't have. They're Nishnawak. They wouldn't. There's different rules. Rules that there's an ethic. I've heard it referred to or described, and Susan can speak more knowledgeably about with respect to the Nishnawak about this, but a principle that it's unethical to directly confront somebody. You know, sometimes you have to, but it's unethical, it's impolite. You are breaching a rule, a behavioral rule, if you say to the lawyer under that circumstances, what are you thinking? You are wrong. Let's talk about how wrong you are and how right we are. So the appropriate response is to not acknowledge what they said in a substantive way. Correct me if I'm wrong, is that about right? That's right. So, and dude had no idea. And so he thought he had instructions, and he was prepared to march back to Toronto and execute them. And he didn't have instructions. It happens with individuals as well. A lot of the issues that Jonathan was talking about, about inequity historically and personally for individuals, disadvantage, and inability to really engage as a equal with agency with your own lawyer who's supposed to be representing you. That's part of it, and that's certainly true, and I've certainly seen that. It's also true that this principle of non-confrontation and not contradicting people, and that's not because you're timorous or deferential or ill at ease or you don't have the confidence, but because it's wrong to do it. That is why the client does not correct you. And if you don't know that, if you're working with an Anishinaabe person, and that's Anishinaabe people, I wouldn't say it's necessarily true of maybe Haudenosaunee people. I don't believe that. But they, in my experience, will correct you. But anyway, so you have to know who you're dealing with. And another thing, don't mistake you underestimate your client, that whether it's a chief or a young single mother or a young man in custody, or if you assume that their silence is deference to you, lack of confidence, or, God forbid, agreement with what you say. You're wrong. And you're going to walk into court, or you're going to do something that's going to cause some harm, and it's not going to be ethical, because it's not going to be right, because you won't have instructions, and we're required to do what our clients tell us to do. So that's one of the things you have to know, I think, to competently represent Indigenous people. Another, and Adit and Jonathan certainly talked about this, the historical context, the legacy, the reality of residential schools, the implications for children today, for Aboriginal children today, and the 60s scoop. I work for one community in Ontario where they're one of the communities, they were close to the highway, so they were accessible, and most of their children, most of the 30, 40, 50-year-olds in the community, well, the 50-year-olds mostly went to residential school, most of the 30 and 40-year-olds were taken out, and their recollection was that their families were not abusive, where they weren't taken as infants, but they were taken without sufficient grounds from poor Aboriginal Anishinaabe families and placed in foster care or other Crown wardship or adopted out, where they were largely, they say now, incredibly lonely, alienated, and in many cases abused. So that community, when I represent them in child welfare proceedings, I need to know that. And my actions on their behalf, my advocacy on their behalf, has to reflect that. The Children's Aid Organization agency within that jurisdiction is referred to universally throughout the community and all children's aid, child welfare organizations as the wolf at the door. And that is for the highest functioning families as well as the families who are struggling. And my instructions are to keep the wolf from coming through the door. And that's not a political statement. That's not an esoteric or philosophical or militant. That's because they've experienced it. They have experienced the concrete, very tragic reality of being wrongfully taken from their families and their community, and suffering as children, and they're trying to protect their own kids. So we do some very robust litigation in that jurisdiction, or we have in the past. The agency is not behaving as audaciously anymore. I don't know why. And another thing that's imperative that you need to know, I think, to be competent, is that Aboriginal children, they struggle today. Their parents, their grandparents, their aunts and uncles struggled as children, faced very difficult circumstances. And that's most of what Canadians know about Aboriginal children. But that is not who we are. It's part of who we are. It's part of what our children's reality is. But that's not what we're working so hard to preserve. That's not why we continue to identify as Secwepemc or Anishinaabe or Haudenosaunee or Cree people. That's not why many Indigenous people's primary citizenship and identity is, and this is not true across the board by any means, but many Indigenous people, their primary citizenship, they consider it to be with their own nation and not with Canada. So what is that? And what do our nations, what do our children need to know to fulfill their citizenship obligations, both within Canada, to Canada, and they're learning that in school and at home and on TV and everything they're immersed in, but within their own nation. So whether they need to know their treaty, the history of their land, they need to know their territory, they need to know their relatives, they need to know, or hope many children don't have this opportunity, but ideally they know their language, they know their community's laws, their nation's laws, and their culture. Because they're learning all of this about Canadian English language, territory, political structure, law. They're immersed in it and learning it in the school, and certainly if they're removed from their community. But when children don't learn this, whether it's at home or through other activities within the community, then they're not going to be able to fulfill their obligations as citizens. And often with the kids who are removed, they're made crown wards and adopted out, or languish in the system. I'll talk a little bit more about that, what happens to those kids, but they're ill-prepared once they hit adolescence and beyond to fulfill any obligations to anyone, because they don't identify, they haven't been able to internalize the Canadian norms because of an interruption in their development, and they're similarly unable to, they don't know what their obligations are within their own community and their own nation, and with the result that they're lost. So as a parent, as a community member, and as a professional, certainly working under the auspices of the Child and Family Services Act, which has these very prescriptive mandatory provisions that these things at least be acknowledged, recognized, considered. And I think given the scheme of the Act, in good statutory interpretation, I would suggest that, or do more than suggest, that these be super-weighted factors, and that acknowledgement means executing and giving life to identity, culture, really citizenship for the children. I'll give them what they need. So I'm going to talk a little bit about, many people in the room will have heard Adit's executive director speak about Ken Richard from Native Child and Family Services talk about this sort of paradigmatic circumstance that a child who's removed from community, whether in the 60s, 70s, or today, and where these factors are ignored, which they often are, Sarah and I are dealing with a case right now where it could be 1961, but what happens, the course, and Jonathan will have seen this in the work that he's done as well. So children are often removed, or usually removed under the age of 3, whether it's from a birth alert or during infancy or early toddlerhood, because of difficulty, either because of poverty, maybe neglect, maybe abuse, or maybe it's discrimination on the part of the agency, and none of those things is actually, there's not a real protection concern. We do still see that. They spend between 1 and 3 years in a series of foster placements. They're lucky if they have only one. Those are by and large non-Aboriginal families. By the way, very few Aboriginal families are willing to step forward and work with an agency and be scrutinized by an agency to the extent that they'd be accredited, as Jonathan said, as a placement still today. So then they're placed in a non-Aboriginal adoptive home or long-term placement. The non-Aboriginal adoptive family is ill-suited or ill-qualified or not qualified to transmit any of the stuff that I'm talking about identity. How do you grow into a Cree, Anishinaabe, Haudenosaunee, Secwepemc person, adult? Sometimes they make a tentative attempt. Sometimes they make they try to make contact. You might leave a message for the chief, again, without identifying themselves, and say that, well, you never called me back. So, and even where more robust attempts are made, where the families try hard, and these are very well-intentioned families. They love these kids, mostly. Take the children to powwows. Try to read them stories from the library. The impact on the child is sometimes it has a helpful effect. At least they know there are other Aboriginal people around. But imagine the experience of a visibly Aboriginal child living with a Caucasian family taken annually to a powwow, who has no other exposure to directly in-person exposure to Aboriginal people. They're sitting in their stroller or by the side of the circle looking at all the other Indians. They don't get to touch or talk to. They don't know what people are doing. So it's like a viewing. But they don't know how to, and their family doesn't know how, their adoptive family doesn't know how to help them penetrate what's going on in the powwow. So, powwows are great gatherings for our communities, but they are, and I would suggest for children who are raised outside of our communities, they're necessary gatherings, but they are not sufficient. And, Ken Richard has written that in some cases they can actually do more harm than good for the reasons that I've just talked about. So, so the child grows up with little or no contact with their community of origin. Their main exposure to, or only exposure to Indigenous people is through the press or what they see on the streets, with street-involved Indigenous people. Maybe the stories they read, which seem like fairy tales, things that aren't real, things that have no real application within their lives, by people who just don't have the knowledge to transmit and imbue the significance of the stories that are captured in those books. And they don't know how to talk to other Indigenous people. When I go to Secwepemc, I spend a few months every year. I try to spend a few months every year within my own territory in British Columbia. The first few days that I'm there, it takes a while for me to realize that people are actually talking to me, because the in-your-face, eye contact, direct manner of speaking is not how my people speak to each other within our own cultural milieu. So, if I'll be walking and somebody, an elder will be walking behind me and speaking very softly in a way that they don't start by saying, Catherine, and I am talking to you, or the tone that grabs attention, in mainstream non-Aboriginal Canada. And it really takes me a few days to reacculturate myself to just being able to hear people speaking to me and realizing that I'm being spoken to, that I have to be listening, and that's how I should be speaking to people as well, not grabbing them by the ears and saying, I'm talking to you. That's not how I actually do it here. But.
Well, just that one time.
Law Society. Okay. So if you don't know that, then how successful, if you're not raised with that, and you're actually raised and trained overtly with, if you do not make eye contact when you're speaking to somebody, then you look like a weak, dishonest, kind of sleazy person. Well, in my territory, it's you don't look directly in somebody's eyes unless you're very, very close to them. So, the children grow up and they don't know how, not just the citizenship, but they don't know how to speak to other people from their own community. So they're, and what happens to these kids? They do not assimilate. They do not thrive. It's not controversial. The exact number might be hard to pinpoint, but it's not controversial that somewhere between 50 and 90%, 50 and 90%, so more children than not, at least, most Aboriginal children who are placed in non-Aboriginal long-term or adoptive homes leave the care and custody of those homes before they reach the legal age, so 18. What we see in Toronto, what Jonathan sees in Toronto, what Native Child and Family Services sees in Toronto, is that many of these children, it's at the point where they're trying to individuate, and who am I as an adult? Who am I? I'm not a child, and they look around and they don't see anything that tells them how to be who they are. This is the explanation that the scholars and the social workers and the policy people, the people who studied this, have given to me and have testified in some of my cases. And so they're at sea and they leave their adoptive home. Age of 13, 14, 15, they leave. And where do they go? Well, I'm the parent of a 16-year-old, and we all know how vulnerable adolescents are, even the ones that are right at home and right under our noses. It's tremendous turmoil during this period, tremendously risky time for virtually every kid. These are kids who have no one caring for them. They leave their home to what? To the street. Well, they've seen some Aboriginal people down there, so they go and find, there's many really people that I have a great deal of affection, Aboriginal people who live in Toronto who have been or are now homeless, but they may not be the best role models for 13, 14, and 15-year-olds who are looking for how to be and who to be. And they are lost. They die. They're killed through suicide, violence, overdoses. If not right away, then in their early 20s, and they're lost to the stroll, and they're really lost to their families and their communities and to themselves. So, and if you don't know this, and you're involved in, say, a child protection proceeding involving a 2-year-old who appears to be bonded to attached to their non-Aboriginal foster family, and so that placement's really working out. You need to think about the 13 and the 14-year-old. Every person in the room needs to think about that. The judge needs to think about that. The judge really needs to think about that. The lawyers need to know that. The Office of the Children's Lawyer needs to accept that. They know it, they don't accept it. They need certainly the societies and their council need to know it, and if you're representing a family or a First Nation, then this needs to be brought to the court's attention. And there's lots of evidence. It's not hard to pull together the evidence of this. So that, I think, it's a contemporary reality, but I think it's a core competency that will prevent further grave harm being done to Aboriginal children who are in the care of the state or who are in any way involved or at risk in a child welfare sense. And I'm going to close with this, that if you're working with Aboriginal people as a lawyer, it's imperative that if your only exposure is through Aboriginal people, is through the press or through the courts, through criminal or child welfare constructs and processes, if that's your only exposure, then you're not going to have learned who we are, what we do, how we are who we are, and why we are what we are. And in order to be socially, culturally, and from a regulatory perspective, professionally competent and ethical, I would suggest you need to know that, and the way to do it is to educate yourself. Books are necessary but not sufficient. Programs like this. Expose yourself to a socially, culturally, even ceremonially. We participate in a lot of Canadian ceremonies that are non-Indigenous, and we know who you are. We do. We learn in school, we're immersed in it. You need to learn who we are in order to not, through the law and the institutions associated and authorized and the jurisdiction that's under it, do more harm. So,
Mina, well, you've heard about the most important piece of litigation on behalf of Native children happening right now. You've heard from legal counsel for what is, I consider, a properly functioning Native Children's Aid Society. You've heard from Mr. Rudin about the heavy burden that Native families and parents have to undergo when they come in contact with the Children's Aid system. You've also heard about some ADR considerations that the Aboriginal Legal Services has developed, and which seem to be continuing development. You've also heard about practice considerations and cultural competency from Ms. Hensel. And with all of this, we're going to open the floor for questions, but I also would echo Justice Charles Hackland's comments yesterday at the Call to the Bar in Ottawa, where he immediately requested, right off the hop in his speech, he requested that the new lawyers consider practicing in child protection, that there's a crying need for more child welfare practitioners in Ontario. So with that, the floor is open. There's 2 microphones. There are no rules. I'll ask any of the panelists to answer your questions. So microphones are open. Okay.
Hi.
Ms. Murray.
Hi. Hi. I just want to say thank you to all the panelists for your great presentations. As I sit here, I can't help but wonder what the intersection is between the criminal justice system and child welfare system, and wondering whether when we look at the judges in criminal court looking at GLADU reports, are they considering that this is a mother, this is a parent when they're incarcerating people? And I think about the news reports recently out, I think it was out in British Columbia, where they're removing the moms and babies programs in jails. And so I'm just wondering what's happening in Ontario, what are your organizations and individuals as lawyers doing to work on that intersection, and how how we can fix that.
Okay, so let me take a, first let me say that through some research commissioned by the Truth and Reconciliation Commission, and if you don't know, Kim is the executive director there, we were looking at our GLADU reports, that we do GLADU reports at Aboriginal Legal Services, and we've actually found there's a statistical relationship between involvement in child welfare for Aboriginal people and then further involvement in the criminal justice system. And I think, so that speaks to Catherine's point about the impact of apprehension. There is, in the criminal justice field, there is a lot of, people don't really understand when an Aboriginal person comes to court, and this is true of, I think, everyone in court, people have preconceptions of what an Aboriginal person is going to be and what they're going to look like. And someone who is raised, who is adopted or taken into care in any event when they were 6 months old or a year, even though they are Aboriginal and was never raised in the Aboriginal community, is often perceived as not actually being Aboriginal. And so the circumstances of their life, from a criminal perspective that GLADU and IPELI requires you to look at, get ignored. Because there's this notion of, well, an Aboriginal person is someone who knows their traditions, who knows all those things, when in fact it's not knowing those things that in fact are one of the reasons that people come into conflict. So I think that it's true that it's one of the areas that I think is that criminal courts have a real problem with, is not understanding the impact of things like the 60 scoop, or which is now actually more precisely referred to as the millennial scoop because it's continuing. Courts don't understand that the apprehension of children is in and of itself, in many cases, one of the after effects of residential school. I mean, all those, that's not understood. And the challenge then for lawyers, the challenge for judges, the challenge for lawyers is to try and make people understand that. So then it also requires in the criminal justice field that lawyers try and understand the history of their clients and themselves not fall victim to saying, well, I know you're an Aboriginal, you say you're Aboriginal, but you never really were raised, so you're not really an Aboriginal person. So that would be my quick, immediate response.
I'm going to just add sort of my 2 cents to that. Now, the Child and Family Service Act has very specific sections that require the agencies and the court to take the child's heritage into consideration. So it's the obligation of Parents' Council and the CAS Council to make sure that the courts will have that information. So, and that's sort of incorporating what the GLADU principles are in the criminal court. The CFSA legislation itself talks about, in some ways it's parallel. It requires the court to have that information. Now, you were talking about the intersection between child welfare, family law, and criminal court. So at 311 Jarvis, there's a project running which is the Integrated Domestic Violence Court. So not specifically dealing with child protection cases at this stage, so that is a consideration. So right now, they will look, it's voluntary participation. If there's a family law proceeding running and in conjunction with a domestic violence assault charge, they will bring them together in the same court so that the same judge is hearing both proceedings one after the other, so facts don't fall through the cracks, so that a decision in one court doesn't make sense in the other proceedings as well. So there is a recognition in the family law that when you're dealing with family violence, at least, that you need to look at the big picture and look at it together. And I think there's some thoughts to bring that also into the child protection scheme as well.
Probably one of the most common ones, Kim, is where a Native child has been bounced around foster homes all their lives and eventually enter the criminal justice system. And they have no faith in authority. And so they begin their criminal journey by breaching probation orders one after the other, because that's the analysis of GLADU, that they breach court orders because they have no faith in institutions that have authority over them. So I would add that as well, yeah. Ken?
And I don't know whether, I'm not, Justice Cohen is speaking to, rising to the mic. And
I just want to, my name is Marion Cohen, I'm a judge at 311 Jarvis, and obviously we do child protection and we have a youth court there. And I understand that the statutes say these things, but the fact is that these issues are not raised. And you can go through a whole career, as I have done, on the bench and not have it brought to your attention that you have an Aboriginal youth, or, well, now we have Native Child and Family Services, but not have it brought to your attention what the history is of the people that are in front of you, and their family history and their cultural history and their history in Canada. So I say to the lawyers that are here that you have to learn how to raise these issues, and you have to start to raise these issues, and you have to start you have to educate, because it's a very slow, long process, because I'm so late in my career and I'm just educating myself now, and I see the importance of the whole thing. And the lawyers have to make the arguments. And the thing is that when you practice law, you're busy and you're running, and there's a style of practicing law, and lawyers emulate the style of other lawyers. And if other lawyers, the established lawyers, are not raising these issues, the lawyers get into the style of being like the other lawyers. And there's plenty of good lawyers, but it's not being talked about, it's not being raised. Now we have courts, we have a Gladue court, in our court we have the Aboriginal Youth Court. We're learning how to approach the problem. We need to learn how to approach it in child protection court. We need to learn how to approach it in all our courts. So it's not enough that it's in the statute. The lawyers have to start making the arguments and solving the problem. If they are bonded, the baby's bonded to this family, non-Aboriginal family, at the age of 2, there's going to be a problem when they're older. How do you make that argument? When, you have to start right at the beginning of the case and start making the arguments. So that's all. I feel like you're all, all the lawyers that are here, they want to do this, so do it. Like, don't raise the issue every time you have a chance. That's what I would say.
Thank you. Justice?
There is a problem, though. We should be clear that the CFSA does not, in fact, refer to Aboriginal children. The CFSA's requirement, and I'm going to go on this, the CFSA speaks only of First Nations children, and this is a huge problem. In terms of the requirements for consultation, and I know children's aid societies in Ontario that once they know that the child does not have status, they pulled kids out. Okay, kids not going to the Friendship Center anymore. And I consider the CFSA to be in violation of the Charter. I think it's discriminatory, and the provincial government, when they last did a CFSA review a couple years ago, was not interested in dealing with that. But that is a real problem, that the actual statutory duty applies to First Nations children. It does not apply to Aboriginal children. Now, it's not a problem in Toronto because Native Child works with all families, but it is a huge problem in other jurisdictions where it is the Children's Aid Societies, their own interpretation of how they see the word Native, that makes a difference in terms of who's getting access to programming and how things can be argued. So there is still a fundamental inequity in the Act that has to be addressed.
The exact definition is an Indian or Native child. An Indian is an Indian as defined in the Indian Act, which is basically status. And a Native child is a child from a Native community. And what's a Native community? That which the minister has designated, and the minister basically has not designated any Native communities. So the special provisions of the CFSA actually only apply to status Indian children. Now, as Jonathan said, our clientele are self-identified, so if they're involved in child welfare through our agency, all the special provisions, we look at all of the special provisions applying to them. It doesn't speak to Métis, it doesn't speak to Inuit, even though they are the Aboriginal people in the Charter. And there was a very recent case, which I don't even remember the name, which talked about that for the purposes of the Indian Act, non-status Indians are Indians, and I mean, it's much more complicated, and I can't remember the name of the case. Maybe Jonathan or Catherine can speak to it more. So definitely in 2015, when the CFSA is set to be reviewed, and specifically the provisions, the compliance provisions for the Part 10, that is something that should be raised, because our First Nations families, our Aboriginal communities, are not just status Indians. And don't forget that the definition is a federal definition, and correct me if I'm wrong, the definition is, the idea of it is to keep the group small, because the federal government has obligations towards that group. The larger the group, the larger the group that they have obligations to. So the definition keeps the group small, though McIver decision expanded it to some extent. But still, if the CFSA, if the legislation is supposed to remedy a wrong, then the group is much too small.
Thank you. Thank you, Edith. There's a lady at this microphone.
I just wanted to raise the issue of, I do some work in anti-human trafficking, and some of the issues that were discussed by the panel, to me, seem to explain why there might be an increased vulnerability to some young Native persons being trafficked or falling prey to traffickers. And I'm wondering if that is being looked at.
Yeah, let me think about how to say this diplomatically. Okay, so the BC Missing and Murdered Women's Inquiry was supposed to look at, amongst other things, that I would say that was squarely within its mandate, and that was an inquiry that was called a few years back to look at the review, both the prosecution of Robert Pickton and the circumstances that led up to his arrest and conviction for the murder of, well, he was only convicted of the murder of 6 women, but he was responsible for 49 or 50, and most of those girls and women were Aboriginal. Most of them were street involved. Most of them were involved in the sex trade. Unfortunately, that particular inquiry was a huge missed opportunity, because really the families of the women were represented, the police by hordes of lawyers, taxpayer funded, and the attorneys general federally and provincially. But the Attorney General for British Columbia denied funding and therefore shut out from that inquiry. I was counsel with Gwen Brodsky for the Native Women's Association of Canada, which had funding, we had standing. We did not have funding, so we had to withdraw. And all the downtown east side and organizations and women's organizations. Native Women's was the only organization that got full standing. The Assembly of First Nations also withdrew. They had sort of policy standing, and a number of other Native organizations. So that was a missed opportunity. It should be. There's a call across all the provinces, the provincial ministers for the Attorney General have called on the federal government to look into the issue of missing and murdered women. There's hundreds and hundreds, depending on whose figures you listen to. The Native Women's Association puts it at over 500 missing and murdered Aboriginal women. Many of them were in very vulnerable places. So this is what you're talking about. It would be part of that analysis. It would be one of the lines of inquiry and study in such a commission. The federal government has not seen fit to call such an inquiry. It's a pressing concern, because you know, if you work with these populations, how very vulnerable they are, and how many of them are Aboriginal, and the tragic outcomes for them.
And also, about 5 years ago, I worked on a project in Montreal with the International Children's Rights Bureau. They did a child trafficking project of children being trafficked in and out of Canada. And I will also try to be diplomatic about this. They struggled with this issue of whether or not to attempt to gather data on the trafficking of Aboriginal children within and across jurisdictions, like both, from the territories and across the provincial lines. And they did try to gather some data on that. So the report is available online. And I can give you the website. I can't remember it off the top of my head, but I can certainly, if you email me, I will email you the report. And there was some follow-up work on that, but it's from my experience working on that project, it's a very difficult thing to track. But some work has been done on it, but not much.
Okay, thank you. We are at the end of our time allotment. And I want to just read a comment from a participant on webcast. He says, or she says, thank you to the Law Society, and specifically Marisha Roman, for organizing this program, and thanks to all the speakers today. I can't say it any better. Thank you, Marisha, and all our speakers. The day is not over. We are going to, first of all, we'd like to remind you to fill out your evaluation forms before you leave and leave them on the table outside. And we would now ask you to join us upstairs in Convocation Hall for a reception and for a very dynamic speaker and comments from the Treasurer of the Law Society. Thank you.